They are basically declaring here that because the one was thrown out, it can't be held liable under FIHA. I want to get your thoughts. Does that notice from Lyman, did that set up a tone for you that you felt like he was definitely setting this up? And do you think Wayfair has answered him well in both of these motions to potentially get 2 more of Blake's claims gone?
I would be upset if you are rooting for Baldoni, because to lose before getting to trial is embarrassing, especially for the level of lawyers that we have here. Harassment or the forbidden conduct or the protected conduct wasn't in California. So if the unlawful conduct that's supposed to protect you isn't protected by California law, how can we retaliate against you in violation of California law?
2 more of Blake Lively's claims could be gone before this case ever reaches a jury. And based on what's come in from the Wayfair parties over the past week, and more importantly, based on what Judge Lyman wrote in his own summary judgment ruling weeks ago, there is now a credible argument that this is exactly what he was setting up all along. Let's establish where things stand. 10 of Blake Lively's original 13 claims have already been dismissed. What survived were the FEHA retaliation claim against Wayfair and the Movie LLC entities, TAG's aiding and abetting liability, and a breach of contract claim related to her rider. Those 3 things, that's what's left of a lawsuit that was supposed to rewrite Hollywood standards around harassment and retaliation on film sets. Now Wayfair has filed 2 new motions. One targets TAG directly, the other targets the retaliation claim itself. And if both succeed, and the legal assessment from people who have read the filings carefully puts the probability at around 90%, then what's left is a contract dispute, not a harassment case. Not a retaliation case. A contract dispute about whether the terms of Blake Lively's rider were honored, and contract disputes settle quietly. With no jury, no verdict, no public accounting of what actually happened, it's worth pausing on that 90% figure before going further. Because numbers like that don't come from casual observation. They come from people who have spent careers navigating FIHA claims, who understand what California employment law covers and what it doesn't, who have read Lyman's ruling carefully enough to recognize what he was doing when he spent 2 pages laying out the exact legal standard that Wayfair now invokes.
Lively, nothing happened in California. And if nothing happened in California, the California law doesn't, apply to her. And that's a really good argument. Arguments that when you represent people that work both in California and outside of California, or, work for a California employer like I do sometimes, but they never come into the state, you kind of have to worry about these things of like, wait a minute, I don't even know if California law applies to you.
That number represents a consensus view among employment lawyers who follow this case that the legal ground under the remaining claims has become very difficult to stand on. Not impossible, nothing in litigation is certain, but very difficult. Let's start with how we got here, because the sequence matters. Judge Lyman's summary judgment ruling was an unusual document. Beyond the 10 dismissals, it contained something that legal observers started flagging almost immediately, a footnote. Lyman wrote that there may exist a question regarding the application of the FIHA retaliation statute where the allegedly retaliatory conduct had a sufficient territorial nexus to California, but the underlying harassment about which the plaintiff had complained did not. He then said no party had raised that issue, so he had no occasion to address it, but he raised it himself, in a footnote, in a ruling that everyone involved would be reading carefully. He also wrote, in a separate section, that the court withholds judgment, not denies, not grants, but withholds with respect to TAG's liability for aiding and abetting retaliation. And then he referenced the California Supreme Court case Raines versus HealthWorks directly, which is the precedent that establishes when a non-employer business entity can be held liable under FEHA. These were not throwaway observations. Federal judges don't bury legal arguments in footnotes by accident. What Lyman appeared to be doing, and what multiple legal analysts have now noted, is essentially publishing a roadmap. Here are the 2 arguments I haven't been able to address yet because nobody raised them properly. Here is the case law that applies. Here is the exact standard you would need to meet.
Is a good argument. One that I thought some of it might have happened in California just because she started it from here, right? With the DOVH complaint, with the CRD complaint. I thought some of it would be here that would be actionable. Apparently it's not. That's not good. That's really not good for her.
Wayfair read that roadmap and responded with 2 motions that follow it almost precisely. There's a version of this where Lyman's roadmap is simply a conscientious judge being transparent about the limits of what he could address in a summary judgment motion, flagging issues for the parties to properly brief. That's a legitimate reading. A thorough judge sees a legal question lurking in the record, flags it so nobody can claim surprise, and lets the adversarial process work. That's textbook federal court practice. But there's another version one that employment lawyers familiar with Lyman's approach find more compelling, where the specificity of the roadmap goes beyond standard practice. He didn't just flag the tag issue generally, he cited the controlling case. He didn't just note the extraterritoriality question. He laid out, across 2 pages, the precise legal standard that would apply if someone were to formally raise it. That level of specificity in a summary judgment ruling reads as more than a flag. It reads as an invitation, and Wayfair accepted the invitation. Wayfair read that roadmap and responded with 2 motions that follow it almost precisely. The first motion, the tag motion, is the more straightforward of the 2, and the legal analysis on it is fairly clear. TAG is a crisis management and public relations firm. They were retained by Wayfair to manage the studio's reputation during the press tour for It Ends With Us. What they actually did was PR work, managing media narratives, running online reputation campaigns, contacting journalists and publications.
I think these are very good. I think these are very good motions, but I wouldn't be, I know you sound upset. I don't know if you really are upset, but I wouldn't be upset if you are rooting for Baldoni, because to lose before getting to trial is embarrassing, especially for the level of lawyers that we have here.
That's what a crisis PR firm does. FEHA, the Fair Employment and Housing Act, is California's employment discrimination law. It creates liability for entities that discriminate against employees in employment-related activities: hiring, firing, setting compensation, establishing workplace conditions, managing who gets promoted and who gets pushed out. The California Supreme Court in Raines v. HealthWorks established that non-employer business entities can only be held liable under FEHA if they actually carry out these kinds of employment functions. TAG did not carry out any employment functions with respect to Blake Lively. They had no authority over her hiring, her pay, her working conditions, or her standing in the production.
Jurisdictional issues for attorneys, these are jurisdictional or procedural issues that are very important, because without these jurisdictional thresholds, then everybody can come in. Like, California is a great state to sue employers, and let's just all come in.
They were a vendor hired to do communications work. Arguing that they should face FEHA liability for running a PR operation, even an aggressive and arguably unethical one, is a significant stretch of the statute, and the California Supreme Court precedent suggests it's a stretch the law doesn't support. The policy argument that Wayfair makes alongside the legal one is also significant. If courts were to rule that a PR firm can be held liable under employment discrimination law simply for doing PR work on behalf of an employer, the implications extend far beyond this case. Any company providing services to any employer could suddenly face FEHA liability based on how that employer treats its employees. Courts are deeply reluctant to create new liability frameworks with that kind of broad reach, and Lyman has been explicit throughout this case that he has no intention of creating new California employment law from a federal courtroom in New York. The TAG motion, based on the legal framework, looks very likely to succeed. The question of whether anything TAG did constitutes an employment function under FEHA is not particularly close. Calling the Daily Mail is not an employment function. Running Reddit threads is not an employment function. The legal standard is clear. The precedent is on Wayfair's side, and Lyman himself appears to have flagged this vulnerability in his own ruling. The second motion is more complicated, more interesting legally, and more consequential for what happens next. This is the motion targeting the retaliation claim itself, the centerpiece of what remains of this lawsuit. And the argument it makes is an elegant piece of legal architecture that rewards close reading. Here is the chain of logic, laid out as precisely as possible. FEHA's anti-retaliation provision protects employees when they oppose, and this is the statute's own language practices forbidden under this part, meaning practices forbidden by FEHA itself. Not practices forbidden by some other law, not practices that are generally considered bad behavior, but specifically practices that FEHA identifies as unlawful. Now recall what Lyman already ruled. The alleged sexual harassment, the circumcision comment, the reference to an adult video, the comments about weight, the filming of birth scenes, all happened on a film set in New Jersey. Lively is a New York resident. She was shooting in New Jersey. New York's FEHA equivalent does not apply to New Jersey. The harassment claims were dismissed because the underlying conduct happened outside the geographic scope of FEHA's coverage. So, the conduct Lively was complaining about was not forbidden by FEHA, because FEHA didn't cover it. Her complaints about that conduct were therefore not complaints about practices forbidden under FEHA, and if her complaints weren't protected activity under FEHA, there is no FEHA retaliation claim for whoever responded to those complaints, because the retaliation provision only applies when the underlying complaint was itself FEHA protected. The retaliation claim needs a protected complaint as its foundation. Take away the protected complaint because the underlying conduct wasn't FEHA covered and the claim collapses. Lyman's original rationale for keeping the retaliation claim alive was that the alleged PR campaign was directed from California, creating sufficient California nexus for FEHA to potentially apply to the retaliation itself. That reasoning focused on where the retaliation happened. Wayfair's motion is now drawing a different distinction. The question isn't where the retaliation happened, it's what Lively was opposing when she complained. She was opposing the on-set conduct. That conduct happened in New Jersey. It was outside FEHA's reach, so her opposition to it was never FEHA-protected activity. The California address of the people who ran the smear campaign doesn't change that foundational problem. Think of it as two doors. Door 1 is whether the complaint was about FEHA-forbidden conduct. Door 2 is whether there was retaliation for that complaint. Lyman's original analysis essentially tried to reach Door 2, the California nexus, for the retaliation without fully resolving whether Door 1 was ever open. Wayfair is now arguing that Door 1 was never open. And if you can't get through Door 1, it doesn't matter what's behind Door 2. Lively's best counter-argument is the good faith belief doctrine.
California, when Wayfair was back, and then Tag is located in California, and these emails and messages and things that they're doing are happening in California, does that make it a California FEHA notice?
No, because the protected activity, remember, the protected activity has to be in California.
There is a reading of FEHA under which a complaint is protected activity as long as the person making it had a reasonable, objective, good faith belief that they were opposing workplace discrimination, even if that discrimination turned out to fall outside FEHA's technical coverage. Under this reading, Lively would argue that she reasonably believed she was opposing illegal employment conduct, that the New Jersey versus California geographic distinction was not something a non-lawyer employee could be expected to have navigated on her own, and that punishing her for raising those complaints regardless of their technical legal grounding is exactly the kind of chilling effect on harassment reporting that FEHA is designed to prevent. This argument has genuine force.
Harassment or the forbidden conduct or the protected conduct wasn't in California. So if the unlawful conduct that's supposed to protect you isn't protected by California law, how can we retaliate against you in violation of California law?
The social policy concern it raises is real, and it's worth stating clearly. In Hollywood and in many industries, very young people trying to establish careers are frequently subjected to conduct they know is wrong, but are terrified to report because of the professional consequences. If employment law creates a framework where you can be punished for reporting harassment that technically falls outside the statute's geographic reach without any protection that discourages exactly the kind of reporting the law is supposed to encourage, the chilling effect on legitimate complaints is a serious policy concern, and it's one that Lyman will likely have to weigh. Wayfair's counter to this is that the good faith belief standard requires the belief to be objectively reasonable as measured against existing substantive law. Not against what someone wished the law said, not against a layperson's general sense that something felt wrong, against what the law actually says.
Isn't protecting you from the unlawful conduct from the beginning. How can California protect you from you being punished for that, for complaining about that conduct?
If FEHA didn't cover the New Jersey conduct, and the court has already ruled that it didn't, then it was not objectively reasonable to believe that complaining about it was FEHA-protected activity. The good faith belief has legal limits, and those limits are defined by what the law actually covers. This is where the legal debate genuinely becomes uncertain. Not in a way that suggests the motion will fail. The jurisdictional argument is strong, but in a way that means Lyman has a genuine doctrinal choice to make. He can read the good faith belief doctrine broadly, giving Lively some protection even where FIHA's technical coverage didn't reach, and keep the retaliation claim alive. Or he can read the doctrine narrowly, consistent with how Wayfair is framing it, and dismiss the claim. There's something important to understand about what's at stake in that doctrinal choice. Beyond this specific case, California built FIHA to be one of the most protective employment discrimination statutes in the country. It was designed deliberately to give workers broad protections and to make California an attractive place to bring employment claims.
But let's put her aside and think about everyone else, and it still happens, especially in California, a lot of abuse against very young women trying to get into the industry where they're too afraid to burn the bridges by making these complaints.
The flip side of that is that California courts have also been careful about the statute's reach, who it covers, what conduct it governs, and which employers and entities fall within its jurisdiction. The extraterritoriality question, how far California law reaches outside its borders, is one the state's courts have been refining for decades. Lyman is a federal judge applying California law. He doesn't want to stretch that law further than California's own courts have stretched it. And nothing in the California Supreme Court's precedents suggests FIHA was meant to cover employees working entirely outside the state on projects with no California connection beyond the studio's address. His own roadmap suggests he's leaning toward the narrow reading. But the good faith argument gives him cover to go the other way if he decides the policy concerns are weightier than the jurisdictional ones. What happens if both motions succeed? The tag aiding and abetting claim automatically falls. You cannot aid and abet a violation that didn't exist. The retaliation claim is gone. What's left is the breach of contract claim about Blake Lively's rider. That's a claim about whether production honored the specific contractual commitments made to her regarding working conditions, authority over creative decisions, and other terms of her deal. Contract claims of this kind, between talent and production, almost always settle. The financial exposure is bounded and calculable.
Retaliated against later, even though something didn't rise to the level of SH? No, we shouldn't do that. So we should, as a society, say, hey, we shouldn't punish. We shouldn't fire, we shouldn't demote, we shouldn't punish women who bring up these SH complaints. And if we do that, that's a violation of the law.
Both sides can model the realistic range of outcomes at trial, compare those numbers against the cost of 5 weeks of litigation, and find a settlement figure. That figure changes hands. Both sides issue a statement saying they're pleased to have resolved the matter. The lawyers close their files, and the case is over. No jury verdict. No definitive finding about what happened on that film set. No public accounting of whether Baldoni's behavior constituted harassment, or whether the PR campaign constituted retaliation, or whether Blake Lively was targeted or simply fought back. Those questions, the ones that made this case feel important to so many people, just never get answered. And here is what makes that outcome genuinely frustrating from multiple directions at once. If you believe Baldoni was treated unfairly, that the initial media narrative painted him as a predator based on a one-sided story, that he spent months with his reputation destroyed while being unable to fully defend himself, then a settlement on a contract dispute means he also never gets to fully defend himself in front of a jury. The questions about what actually happened never get put to 12 people who hear all the evidence. The text messages, the recordings, the depositions, the documentary evidence that both sides have been building, none of it gets tested in the adversarial process that a trial represents. Baldoni's supporters want a verdict that addresses the narrative. A contract settlement doesn't give them one. If you believe Lively was harassed and retaliated against that, real things happened on that set. And during that press tour, that should have been addressed, then a dismissal on jurisdictional grounds, means she goes forward saying the legal system couldn't reach what was done to her, not that a jury found her claims unpersuasive. That's a meaningful distinction for her personally and for how this case reads in history. Being dismissed on a technicality is not the same as being found wrong. She will make that argument, loudly and persistently, and she won't be entirely wrong to do so. Both outcomes are unsatisfying. Both leave the underlying questions permanently unresolved. And the procedural technicalities, which are real legal concepts with legitimate importance for how jurisdiction works, end up doing more to shape the outcome of this case than any factual determination ever will. That's not how people imagined this ending when it started, but it may be exactly how it ends. there is still a scenario where Lyman denies both motions, sends the remaining claims to trial, and gives both sides the jury verdict that everybody has been building toward for over a year. That requires him to override his own apparent roadmap, to read the good faith belief doctrine more broadly than Wayfair's framing suggests, and to decide that the policy concerns around discouraging harassment complaints outweigh the jurisdictional technicalities. It's possible. Judges surprise people, but based on everything in the record, the footnote, the withheld judgment on tag, the 2 pages spent laying out the exact legal standard, Wayfair now invokes the weight of the evidence, suggests Lyman has already decided where he's going. The 90% assessment isn't coming from nowhere. It's coming from people who have read the briefs, tracked the case law, and understand what it means when a federal judge spends that much time in a summary judgment ruling, building the foundation for arguments he then leaves for the parties to formally raise. That's not standard judicial practice. That's something closer to instruction. What comes after these rulings is, in all likelihood, a contract dispute that settles quickly, a joint statement from both sides, and a case that ends not with a verdict, but with a procedural fade, the loudest, most consequential celebrity legal battle in Hollywood in years, and it may close not with a bang, but with a wire transfer and a press release that says almost nothing. The one remaining question worth watching is what happens with evidence suppression. Lively's team has been seeking to exclude certain materials, Sony emails, testimony from specific witnesses, other evidence that the other side presumably wants in front of a jury. What Blake Lively is trying to keep out of a courtroom is described by those who've reviewed the motions as significant. If the case somehow survives both of these motions and reaches trial, the evidentiary battles that follow may matter more than anything else in determining what a jury ultimately sees, and what they're prevented from seeing. But the more likely scenario, at 90%, is that the trial never happens in any meaningful sense. The 2 motions get decided, the case contracts to a single contract claim, the lawyers negotiate, and the public never gets the answers it spent over a year waiting for.